Good morning. Welcome to the Court of Appeals. The court will consider several matters today. In just this case, State versus Lucke, we were of the opinion that oral argument would be helpful to our consideration of the case. So you're the only ones here to argue today. And if anybody else is here expecting to argue in a minute, not going to happen. We are pleased to have Judge Michelle Christensen Forster, our presiding judge, join us today on this panel. She needed to do that remotely, but we've had reasonably good experience with this before. It seems like she's everywhere. I've got a monitor. Judge Tenney has a monitor. She's here on a couple of walls. So we won't miss you, Judge Christensen Forster, if you should have a question along the way. We allow 15 minutes aside for oral argument. It appears that appellant is going to save 3 minutes for rebuttal.
That's correct, Your Honor.
And we do appreciate it if counsel, when they come to the podium, each time you appear, please state your appearance for the record, because we occasionally go back and listen to some part of the argument, and it's nice to be reminded who is saying what when. Likewise, because we're both live streaming and recording the proceedings, when you're at the podium, don't stray too far away from the mic or we will lose what you are saying. So with those preliminaries out of the way, unless I've missed anything, we'll hear your argument.
Good morning, Dylan Carlson for the appellant, Mr. Scott Lucke. Now, while the two issues raised by Mr. Lucke do share quite a few similarities, I'll do my best to keep those two separate and take the issues in the order that they were raised, starting with the invalid waiver. And it seems like there's a few points here where the two sides seem to agree, and that's that Mr. Lucke's waiver was explicit, therefore is preserved, and also that the colloquy attempted by the district court was insufficient, so we need to look to the record to determine its validity. But there is a problem there with some uneven case law as to where in the record to look. I don't think in this particular case it matters whether we look at the waiver at the time it was made or the record writ large. Regardless, I think that comes out as an unintelligently waived right to counsel. If we look at the time that the waiver was actually made, which is at the preliminary hearing, right before the preliminary hearing began, Mr. Lucke had essentially planned on hiring counsel, decides not to, and ends up representing himself. Now, we don't have any colloquy on the record. That's not until after he's bound over. We don't have anything in the record to show that that was an intelligent waiver. So if we go by that method, I believe most recently laid out in Padoki, showing to look at it at the time of the waiver, I think it's pretty clear there that we don't have any information showing that it was made intelligently.
There's a later waiver with colloquy. You think that one is not the one that matters. It's the one at the prelim that happened without colloquy.
That's right. And so regardless of which one is looked at, I think it still is insufficient. But the fact is that a preliminary hearing is a critical stage, and Mr. Lucke is going through that critical stage without counsel, and voices his intent to represent himself sensibly before that preliminary hearing. And so because that's the first critical stage we have where he's waived counsel, I think that is what matters. But even if we look at the colloquy after he's bound over, I still don't think there's enough information, frankly nearly enough, to satisfy the requirements of Frampton. And that's because we're looking at maybe 3 to 4 questions that are in the 14 to 16 Frampton colloquy, which fall quite short. I think actually it falls more short than this court's most recent case in Lee, where the court does go through at least a few more than that.
Can I take you to a particular place in all this? One of the things that you've stressed in your brief are the number of instances at trial in which he violated procedural rules and rules of evidence and the like. And I'm struggling a little bit with the idea of how far to take that. Do I have it right that the question is whether he understood that he didn't know the rules, as opposed to the question of being whether he actually knew the rules? Do you see what I'm saying?
Yes, and And I do think there's a difference here when a court warns a defendant about the rules, that there are procedures in place that you're going to have to follow. There's a difference between understanding that there's specific rules that you have to follow and just hearing the words.
Right, because we have a lot of pro se litigants who do have full Frampton colloquies, who are fully apprised of all the rights that they're waiving. They go ahead and waive them anyways. They go into court and they muck up the various procedural rules. But I think we'd be okay with that, at least as to the question of whether they validly waive the right to counsel, right?
That's right.
So the fact that he gets to trial and doesn't understand the rules of evidence, I was struggling a little bit with how much weight to really put on that vis-a-vis that, what seems to be the initial question of whether he understood what he was doing, right?
Yeah, and I think that is it's relevant but not dispositive.
Okay.
So if we look at other past cases like West, I believe, where prior to the sentencing, it filed a number of pro se motions, and this court makes a point that the district court had said that a lot of those motions, frankly, would have had an attorney sanctioned and were legally frivolous. And while that in itself didn't make that waiver unintelligent, it did at least sufficiently
So then
weigh.
zeroing in, before I let you off the hook on that angle of it, zeroing in on that, what is it in the record that would tell us that he didn't understand the rules of evidence?
And I think it's the repeated reminding of the court as to specific things that are and aren't relevant. And I don't mean relevant in terms of the rules of evidence, but I mean neither here nor there in this specific hearing. So specifically, he does a lot to try to get his daughter, to talk about his daughter at these hearings. And he's reminded as early at the preliminary hearing, he's reminded later when he tries to subpoena her as a witness, and then he's reminded later again during cross-examination of the alleged victim. So time and time again, he's told that this hearing has nothing to do with this specific person, but something doesn't seem to be connecting there. And I think it's the inability of those warnings to connect with him that really makes the difference. And I think there are other cases where you can see that as well. Again, the most recent case of Lee, where Lee is able to perform quite a bit at the trial, but when he's testifying, he's making essentially a jury nullification argument. He's making an argument that marijuana is legal elsewhere, but it's illegal here. Why am I being charged? And he's unable to recognize why that has nothing to do with that particular hearing. And I think there's quite a bit of crossover there with Mr. Lucke's frustration about the existence of the no contact order.
One of the things that I'm also struggling with in this case is the following. We have the Frampton colloquy, and it gives us, 15 or 16 different items on that list. And Lee has this sort of interesting reference, I think, to what happens if you have a partial colloquy. And what happens if we look at the record and we think that the district court checked some of the boxes but not all of them? And I don't know that there's an answer to the following question, but it's a thing I'm thinking about, so I'm just going to ask it, and the other side's going to get it too. What do we do with these partial Frampton colloquy scenarios? Is there some threshold at which the number of questions that it didn't ask is greater, and so that's the moment at which we say it's tipped the scales? What do we do in this case if we think that the court did some of the Frampton pieces but not all of them?
So when we get a more partial Frampton colloquy like the one in Lee, where it's certainly closer than this but isn't quite there, I think we still would have to look to the record to be able to fill in the holes left by those omitted questions. We may, if we get to a lot more of those Frampton questions than in other cases, it's possible that we may need less information to find that valid waiver. Because a lot of it is already going to be fulfilled by the partial Frampton colloquy. So there, I think we get a borderline mix and match approach, where the threshold for looking at the waiver may be eventually lower.
And then does a notion of substantial compliance come into play?
I think it may, and I think it really depends on the amount of the Frampton colloquy that they're able to get through. In cases like this, where it's just 2 or 3 questions, it's not close. We certainly have to look to the record for most of it. But if they're just omitting a few questions in the Frampton colloquy, then that's going to be much closer than this, and that substantial compliance may come into play.
Doesn't this lead into the question, and if you're not ready to go there, we can spend a few minutes on the colloquy aspect, but doesn't this lead into the question of what error we are looking at here, whether this is harmless error or structural error? I mean, if, to the extent that this case and Utah courts are different than the Third Circuit, who don't look to the full record to decide whether a waiver was voluntarily and intelligently made, don't we, isn't this all just a question of whether Mr. Luck was prejudiced by, if he indeed, his waiver was not knowingly and intelligently entered and made, don't we need to look at if he was prejudiced or not?
So in this particular case, we don't. There are instances of denial of counsel that are not structural error, and that's when it doesn't occur during a critical stage. But here we have multiple instances of critical stages where Mr. Luck does not have counsel, including the entire preliminary hearing, the opening argument at trial, some cross-examination at trial. We have later cases, somewhat more recent, like the 2019 Montez case, where I believe he was represented by appointed counsel for about half the trial. But because he was denied counsel for the first half of the trial, that was still during a critical stage, and so structural error still applied. And so I think here we are still looking at structural error.
I guess I have a little question about that, because I think we pointed out in West, they're both sides of the same coin, right? You don't have counsel because you didn't want counsel, because you wanted to represent yourself. So the denial of counsel is based on the defendant who wants to represent themselves. So isn't that kind of a tension? I mean, Mr. Luck was pretty clear that he didn't, I mean, the waiver was a true waiver. He, at least at the trial, or pre-trial, up to trial, at the trial, he didn't want the court to appoint him a lawyer.
Yes, and I think it comes down to there that the waiver, of course, has to be made knowingly and intelligently. And unless that can happen, I mean, if they're very adamant, they don't want counsel, the waiver is knowing and intelligent, then at that point, the person essentially made their own bed and will have to deal with the consequences. But first, there are some procedures that have to be followed to ensure that they're even able to waive that right. And there are plenty of other areas in the law where we require certain things to be said, certain warnings to go in place before, just to make sure that a waiver is knowing and voluntary. Things like a Miranda, things like a guilty plea colloquy as well. So there are plenty of other areas in the law where a defendant is allowed to proceed at their own risk, but we need to know first that they know that the risk is present. And I think that's what it comes down to there. I see that I'm just out of bed.
Yeah, ignore those zeros. I've got a few questions for you. Staying on the prejudice issue, suppose we disagree with you. Suppose we think that it is not structural error. In your view, what would the prejudice inquiry be? And maybe just to buy you a little bit of thinking time, or maybe you don't need it. As I've been thinking about this problem, it seems to me that the sort of two obvious candidates would be either one, requiring some showing that he would not have waived the right to counsel, or two, which is what I think the state is suggesting in this brief, which is that we would then look to whether there's a reasonable probability that he gets acquitted at trial, even if he has counsel. Is it A, or is it B, or is it something else? If this isn't structural error, what's the prejudice inquiry?
So I think the prejudice inquiry here is just a reasonable probability of a better outcome. And there's a few different points we could look to here, even aside from structural error, which is one, without the help of counsel, he didn't have anyone to assist with plea negotiations. And the fact that he was never informed of the full sentence he could be facing with his charge, I think weighs into that because it would be difficult to enter a plea negotiation when you don't know what the worst possible scenario is. The other possible harm is his entire second issue here, is that if counsel had been present, it's very likely in this scenario that a competency hearing would have been asked for, and that he would not have to face all these critical stages while possibly incompetent.
If we think that that's what the prejudice inquiry is, does our resolution of whether he was prejudiced depend in part on a resolution of the second issue?
It doesn't have to, especially in regards to things like a plea negotiation. I think also when you think about him going from hearing to hearing without counsel, a disadvantage at one hearing is going to create greater disadvantages at the next. And I think that's part of the reason of the structural error here, is that this is something that becomes cumulative at each successive hearing.
On page 6 of your reply brief, you list you discussed three of our fairly recent cases, Patton and Lee and West, and in each of those cases, finding the waiver not knowing and intelligent, we remanded for a new trial. What would be the rationale for doing that if the panels in those cases had in mind something other than structural error? Or is it implicit in the way those cases remanded that the court must have had structural error in mind?
And I think that's the answer, is that implicit in essentially all of this court's case law up until now is that because they are always being remanded up until the point when they waived counsel, if we look at other cases like West where they didn't have counsel for sentencing, I believe that was just remanded for sentencing, then that implies that for any hearing where they didn't have counsel, we have to go back to that point. So I do think that that's implicit in all of the prior case law here, as well as the fact that a lot of it doesn't tend to look at too much for harm or prejudice, that this is structural error.
Can I take you to the competency issue unless Judge Christensen Forrester or Judge Orm want to stay on the waiver issue? Okay. No, we're out of time, but just a few questions on that. Is your argument on the competency issue that the district court should have ordered a competency evaluation before trial, during trial, or before sentencing, or all of the above? Like, which stage are we supposed to be looking at on the competency issue?
So all of the above. It is going to, of course, depend on when there became a probable doubt as to his competency. But I think you find that as early as the preliminary hearing, probably during, while he's trying to cross-examine the officer, maybe as late as the attempted colloquy after. But where the district court is asking him questions, trying to go over the dangers of representing yourself, and his answers are, I don't think anymore. I'm already dead. I'm not going to be made to pick left or right.
I mean, do you agree with the general proposition that on the competency issue, we're only looking at the facts available to the district court at the relevant time?
Yes, certainly.
So in theory, if we're looking at this as a trial competency issue, we're not looking at the sentencing stuff, right?
Yeah, we're not at that time. For the sentencing, we would be looking at that, and because of the fluidity of competency, that may bring up concerns about was he tried while incompetent, but I mean, the information that the court had before trial with his voir dire questions, where do your thoughts go when you think them? Have you ever read Under the Banner by John Krakauer? That information was before the court, before trial.
To the extent that this is about competency to be sentenced, do we have a case in Utah? Are you aware of a case that definitively says that the defendant in a non-capital context has a right to be competent before being sentenced?
Not in a non-capital predicament, but sentencing is a critical stage, and so I do believe with competency is closely tied to also going through the critical stages, similar to self-representation.
But then at that point, do you have a problem insofar as this is being raised for plain error in terms of the obviousness prong? So if we don't have a case that definitively says that the defendant must be competent to be sentenced in the non-capital context, then do you have that particular problem that you can't show obviousness?
For sentencing alone, possibly, but there's plenty of information before trial, I think, to be able to determine. All we have, in addition to the large amount of evidence prior to sentencing, is the evaluation in the PSI. But I think considering the backwards cursive writing that the district court never addresses, the various statements in the voir dire questions, him starting his cross-examination with the alleged victim with "say happy birthday," essentially everything being objected to as irrelevant, and again, just not in the sense of the rules of evidence, but has nothing to do with this particular hearing. All of that information, I think, is plenty to show that there was a substantial question of just possible doubt that he was incompetent at that stage.
Okay.
AP&P had that perception, as I understand it.
That's correct. That's correct. And not just AP&P, but also they had interviewed the victim, his ex-wife, and she had said essentially the same thing. That was also put in the PSI.
If we agree with you on the first issue, the waiver of counsel issue, do we need to reach the competency issue at all? I mean, suppose we were to say we're reversing and remanding because he didn't intelligently and knowingly waive his right to counsel. Would we need to opine on the competency issue, or I've kind of gone both ways on that in my mind.
You wouldn't need to, because there's actually two different ways to take care of the waiver issue. And the first argument is just that the record was insufficient to establish that he had a knowing intelligent waiver. The second is that even if everything was done properly, he wasn't competent to be able to voluntarily waive counsel. So on that first issue, whether the record was sufficient to show a valid waiver, the court could rule on that issue alone without ever reaching the competency issue.
I mean, I suppose under either of those paths, I think if we did remand, well, maybe he does or doesn't get counsel, because in theory he could still waive the right to counsel, right?
That's right. It depends on it, and I think that again comes down to the fluidity of competency. If he, is very different by the time he is tried again, then he may be competent at that time. That just comes down to the district court's determination in performing a proper Frampton colloquy.
That's all I got.
Okay, thank you for the argument. You'll have your, was it 3 minutes?
That's right.
You'll have your full 3 minutes on rebuttal, since it was largely our questions that put you over your time, and we'll hear from the state.
Good morning, Ginger Jarvis for the state. I'd like to sort of start by addressing Judge Tenney's and Judge Christian Forzer's questions by perhaps reframing it from a waiver of counsel case to an invocation of the right to self-represent, which is the constitutional right that's really at issue here, and denial of a defendant's knowing and intelligent choice to invoke his right to self-representation is in fact structural error. And this case sort of illustrates that double-edged coin, because if a trial court is presented with a defendant who wants to self-represent, and against all advice, which he got over and over and over here, and yet still has standby counsel, and in fact, there's really no doubt about the outcome of this trial, given that he knew that there was an order of protection in place, he knew that he was not supposed to contact his ex-wife, and he did it anyway, and he knowingly did it. There is no way that this trial turns out any differently. And if the court in this case had denied him his right to invoke self-representation, that would be structural error.
So are you agreeing that this would be structural error as well? Or are you saying there's daylight between the two?
I'm saying that denial of the right to self-represent is structural error under United States Supreme Court binding case law, Ferretta and McCaskill. And others, Weaver versus Massachusetts, which defines the three categories of structural error. Denial of the right to self-representation is the first one, where in the first category, where the right at issue doesn't necessarily protect against an erroneous conviction, but some other right. And the personal right to self-represent is, according to the United States Supreme Court, as important as the right to have the assistance of counsel. But you don't have to have the assistance of counsel. Although McCaskill says that the court can assign standby counsel and not violate that right, as long as standby counsel does not override the defendant's wishes.
So to make sure I've got it right, the error that he's complaining of here, do you agree or disagree that it would be structural error?
The error that he's complaining of in the briefs is that he did not knowingly and intelligently invoke his right. If And I'm saying that, of course, he did do that. He did knowingly and intelligently invoke his right
Right.
to self-representation. And had the trial court denied that right under these facts, then that would have been structural error.
So I don't want to put words in your mouth. So it sounds like the parties are on the same page on whether this is structural error or not.
Well, he's arguing, my friend on the other side is arguing that that his waiver of counsel was not correct, and therefore that is structural error. But the waiver of counsel is not really the issue, because that's implied in his
So if
invoking
we
his
accept
right,
your
and-
framing of it, that what this is really about is whether it was a proper invocation of his right
Right.
to self-represent, you would agree that
Right.
even there, it's structural error. So it
No,
sounds like.
I'm saying there's no error.
Right, you're saying there's no error, but that kind of error is structural
Right,
error.
I mean, the denial of a right, if you want counsel and you are denied counsel at any critical stage of a proceeding, that is structural error. That's what you're asking me, yes.
Yeah, so if we think that there's an error, then it sounds like, and feel free to tell me I'm misunderstanding, but it sounds like both sides agree that.
I think that depends on what you think the error is. I mean, if you think the error is, and this is why I'm not trying to be
No, please.
disrespectful.
Yeah.
If you think the error is that we didn't go through a laundry list of questions that Frampton wants to impose, and that's structural error, I very much disagree.
So let me try putting words in your mouth.
Okay?
As I understand the state's position, the denial of the right to self-representation would be structural error.
If it
We
was
didn't
knowingly
have-
intelligent, yeah.
We did not have that here because he was accorded his right to self-representation. The fact that that may have been flawed when squared against what Frampton requires is not a structural error.
Right, because I think Frampton begins Utah courts sort of eroding away from first principles. Okay, and the first principle here was articulated in Ferretta, and that is that you have an absolute right to self-represent, even if it's flawed, even if you don't know how to do it. All you have to know is the dangers and disadvantages. That's the language, and that is very narrow, actually, because all you have to know is that, hey, you know what? Lawyers would be better at this because they know the law, they know the rules, they know the procedure.
But it sounds to me, now I'm putting words on the words that you put in the mouth, but it
Fair
sounds to me
enough.
like your attack is on Frampton. I mean,
Well-
Frampton sets this whole structure in place, and we've got 40 some odd years of case law applying Frampton, and you know, we've got all this sort of mushiness of you know, it's the preferred method, but it's not the method. But point being, Frampton says that what we're looking at is whether the defendant knowingly and intelligently waived his or her right to counsel, and that's what we're looking at. So
I mean, I understand that you are bound by Frampton,
we very much so, right?
but you're also bound by Ferretta, and that's the first principle law here.
But Frampton
And-
thinks it's applying Ferretta,
Well,
and Frampton came from the folks down the hall.
let me ease your heartburn about Frampton a little bit, because this case is on all fours with Frampton. You can follow Frampton, and this case still gets affirmed. Because in Frampton, there was no colloquy, and it was affirmed. And here we have standby counsel, and the outcome is not going to be any different. So even if you're applying Frampton, you're okay in this case,
Yeah,
which
how would
I
you
understand
distinguish?
you have to apply Frampton.
We do. How would you distinguish
So-
this case from Patton? I mean, I could pick any number of cases to use as the jump-off point for that question, but how is this case different than Patton in terms of the adequacy of the colloquy?
Well, I think the big problem in Patton, well, first of all, there was no standby counsel. Second of all, I think what really stuck in the court's craw in Patton was that basically there was an ex parte trial. And the guy got on the video and didn't know that what he had been on was, you know, the trial, and that it was all over. And so he didn't have anyone telling him, and actually in Patton, had he been able to tell his story, and the tell his story language is also replete in the case law, but it comes from one of those questions in the Frampton footnote, which is not so much saying defendants don't get to say what they think happened. It's talking about procedure, like, hey, you know what, it has to go in question and answer, and you can't really do that for yourself. So, you know, maybe you shouldn't waive counsel or shouldn't invoke your right to self-representation. So I think Patton is factually distinguishable, first and foremost, because there's no standby counsel. And there was standby counsel this entire time in this trial, and he consulted with the defendant, and he always sought permission before he did things in voir dire or made arguments or did cross-examination. So all of that complies with both Ferretta and McCaskill, which is ultimately the binding case law here.
And Frampton would be binding as well.
Yes, but I think.
I mean,
Yeah, I
understand
get
that this is
it.
sheet taken analytically, but
You're sensing that I have an issue with Frampton,
I'm sensing you-
and I kind of do, because it's putting
coming
in,
through.
it's putting in magic words where magic words don't belong. And, you know, all the Supreme Court says is that you have to tell them about the dangers and disadvantages. A laundry list with special words. I mean, let's say, for example, that they had asked every one of those questions, right? And he had answered the way an appellate court or appellate lawyers would like, because it gives us comfort, because that's what Frampton's really about, right? It's about appellate judges having comfort in reviewing the record. But ultimately, it's the trial judge.
I'm not sure that I totally would go quite as far as.
Well, it's part of it, because how is it
Well,
reviewable?
no, what I understand Frampton to be saying is, look, this is a really important right that a defendant has to represent himself, but we want to make sure, given the dangers of self-representation, we want to make sure that if you decide to proceed pro se, you do so knowingly and intelligently.
I mean-
And then it says, this is how we're going to figure this out.
Well,
And there's
But-
something sort of prophylactic about it.
I mean, I know a
And
lot
if
of
this
lawyers
wouldn't be
that
the
could-
only instance in constitutional law in which there's prophylactic rules to protect the integrity of an important constitutional right.
well, but over and over, like, you really do, though, I think, run the danger of erecting a state court rule that is impeding the invocation of a bedrock, first principle constitutional right under the Sixth Amendment. And if you're putting up this barrier, and we're not gonna do it unless there's penetrating questioning, and you're basically bullying people who want to invoke that right into not invoking the right, you're really risking structural error.
Let's suppose that we're still living in a Frampton world. One of the things that the cases say is that the court has to engage in penetrating questions. That's a phrase that pops up with some frequency. One of the things that struck me here is that I don't see the district court asking him a lot of questions. I see the district court asking him the question of, do you want to waive? But then when we get past that initial sort of salvo, the district court sort of tells him, hey, you don't know the rules of procedure. The other side does, but I don't see a lot of dialogue. Am I missing something in the record there? And if so, does that matter under
No,
Frampton?
I don't know that there's a lot of dialogue. He does repeatedly say, hey, this is what a defendant or a defense lawyer could do for you. Here's what a public defender will do for you. Here's what you don't know, and why it's important to have someone who does know. And at one point, his mom's in the audience, and he's like, yeah, please give him
Yeah.
counsel.
And he's got
but
that little line
the
about
f-
like moms know best. Right?
But Ferretta does not require questioning. It only requires telling the defendant of the disadvantages and the dangers, which this judge did over and over and over. And this defendant did not just trust judges, did not trust lawyers, because of his past experience. And that's his prerogative. It's his constitutional prerogative, in fact.
Can I take you to the sentencing issue, or the competency issue?
Can
Unless-
I just,
No, yeah, go.
just, and this is maybe a point, rather than a question, but there is no, that you know of, there's no US Supreme Court decision that says, that says denial of the right to self-representation. No, I guess this is hard, it's hard formulating the question, right? The right that says a waiver that is not knowingly and intelligently made based upon the record before the appellate court is structural error. Am I
Let me see if I can
formulating that
understand.
question?
I mean, you're talking about a waiver as opposed to an invocation.
Yes.
And
This
so
case
you're
is-
asking me, are there constitutional right waivers that are subject to harmless error review?
Yes.
Oh, yeah, there's a lot. In fact, most of them are. Arizona Fulminante versus Fulminante specifically says that most constitutional questions like that, waivers, are subject to harmless error review. Most of them are, and that's, of course, the Chapman standard beyond a reasonable doubt, right? So, I mean, and again, returning to Frampton, if we're in the Frampton world, this defendant was offered counsel and denied taking it, which means the burden's on him to show that his waiver or his invocation
Except the
was
Supreme
not
Court-
knowing and intelligent.
Except the Supreme Court comes back in later, and I think it was Padaki, and says something that sounds different.
Yeah, I know, and I looked at that tension because there's a couple footnotes in your cases talking
Yeah,
about
we've
the
dropped
tension.
footnotes like that
But-
several times,
But
right?
here's why I think there's actually no tension, because Padaki isn't this case, because Padaki spells out, there's three kinds of waivers. The first one, the true waiver, is actually invocation of the constitutional right to self-representation. And then it goes on to the second two, which are mostly about behavior. They're sort of like jerk and jerk plus. Like, and when at that point does the defendant, based on his behavior and his insubordinance and whatever else, sort of forfeit the right? For one is forfeiture, and the other one is by conduct, waiver by conduct. So, right at the beginning of Padaki, it talks about Frampton, and it says this is not Frampton. So that tension is actually not so much a tension, because and it certainly doesn't even apply to this case, because this case is a Frampton case. He was offered counsel, he refused it, and he had standby counsel the whole time. And he knew the dangers and disadvantages. So it complies with Ferretta. And had the trial court done anything else, then he would have done it, then there would be structural error.
Okay. Can I go to the competency issue, or Judge Christensen Forster? Are you good? Okay. What's your view of the question that I asked earlier? What's your understanding of what the competency claim is? Is it about trial or is it about sentencing, and does that matter?
I think they're just trying to shoehorn in a way to show that his invocation was not valid, not knowing and intelligent.
Another
And-
reason why it was flawed was
Right.
that he was incompetent.
Well, but here's an interesting thing, like, the invocation of the right to self-representation only requires a knowing and intelligent. Doesn't require competency, and it doesn't require voluntariness, which Frampton brings in. Frampton drops in voluntary. To be competent to stand trial is pretty low standard, and it's the same level of competence as competence to waive counsel, and both of those are met. It's just that simple, and that we can tell from a cold record, and also that we can tell from, the judge's interactions.
What's your view on, and I know this is coming a little bit out of left field, but I asked it earlier and it's on my mind. Would you agree or disagree, or would you want to take a look at it on the question of whether a defendant has a right to be competent before being sentenced in a non-capital context?
I think under U.S. Supreme Court case law, there's nothing that says you have to be competent to be sentenced. I'm new here, so I'd have to
Yeah.
research that for Utah law, but I am pretty confident that in a non-capital case. Now, I say that, but I am aware in Utah with the AP&P and the ability here to challenge it. And so I would have, maybe you have to be able to help your lawyer say, hey, this wasn't true and that's not true, and that's because that report follows a defendant.
But
that's just me off the top of my head,
Yeah,
so
like-
I would rather research it better.
Right, and
But not constitutionally, certainly not.
yeah, it's just sort of an interesting question, because I read his brief kind of two ways. There's moments where he seems to be talking about competency in terms of being sentenced, but then there's times where he sort of seems to be folding it back into the trial claim. But if we read his brief as raising a claim that he had a right to be competent before he's sentenced, some of the stuff that comes out in the PSI, it does seem to raise a question about whether he's competent. You've got the PSI evaluator saying, I'm not sure if he's competent. You've got his ex-wife saying, I'm not sure if he's competent. And then he's got his sort of rambling discourse in his allocution that doesn't seem very grounded in reality. And so if we think he's raised that claim, I'm wondering what your response to this question would be, which is, how is there not at least a substantial question about his competency, which seems to be the governing standard?
That's an interesting question.
Like if he's
I
gotten over
don't
those
think-
hurdles,
Yeah, I don't know. I don't think that that's the claim that was raised, but accepting your hypothetical that it
Yeah.
was. I can see where if, based on this record, and if that is raised, I can see where maybe a hearing, simply because he said, I'm not gonna do probation, so just put me in prison. So if he is not competent and the judge does that, because then there's prejudice.
yeah.
And I'm willing to see that, and maybe that would be a,
I mean, at a bare minimum.
maybe that would be a man for a hearing on
Right,
whether,
it
you know.
feels like if the jump off point, I wanted to give you a chance to sort of respond to that, but my instinct is that that if he's gotten to the place in the briefing of saying, my claim here on appeal is that I was not competent and I shouldn't have been sentenced because they needed to do an evaluation. And if that standard, that jump off standard is there a substantial question about that?
Yeah, that's interesting. First of all, I don't read the brief that way. I don't think that issue is raised.
Right,
And my reading of the sentencing transcript, I think he was competent when he was able to assist his attorney, and that's a pretty low standard. So I don't think it's an issue, or a raised issue, but I don't know the answer to that question.
Okay.
But I would, if it's raised, do supplemental briefing.
right. That works. All right, thank you.
Thank
Court has
you.
no further questions. The state would urge you to affirm the conviction and sentence.
Thank you very much. 3 minutes for rebuttal.
Dylan Carlson for the appellant, Mr. Scott Lucke. Just have a few points to touch here. First was Judge Christensen Forrester's question about whether an invalid waiver has ever in itself been found to be a structural error, and other contexts as well where there are waivers. But here I think just a quick syllogism will show that it is structural error, and that's a denial of counsel is structural error, and that an invalid waiver is a denial of counsel. So there we're able to get pretty quickly that a denial of counsel by way of an invalid waiver is structural error. I also think here from the state's argument that Frampton is on all fours with this case is not correct. In Frampton, we have someone who went through this same trial 3 different times. We do have Mr. Lucke's word, he's been through the system twice, but that is not nearly specific enough as we have in the case of Frampton. It's really the difference between doing the same problem 5 times and then doing completely other different problems, 5 different problems. So Mr. Frampton was very familiar with the facts, what was at issue at his specific case. And not only that, but he had the chance to see how useful counsel was in his specific case. Because at his first trial, he watched counsel work through the whole trial and end in a hung jury. Then he also had the second trial that he was able to conduct himself. And these are all on the same charges. These are charges he's able to explain to the jury. He's able to explain to the jury the sentence he's facing. We don't have any of that cogent explanation here from Mr. Lucke. We also don't know whether his past experience is in another state with a misdemeanor. There's no information there for that to be able to make it close to Frampton. And while Frampton did have standby counsel, this court has found that that's not something that cures an invalid waiver. I think it was State v. Petty, a 2001 case. This court explicitly says standby counsel does not offset deficiencies in the colloquy. Then we also have that State v. Montez 2019 case where it wasn't only just standby counsel, but it's appointed counsel handling half the trial. And that's still not enough to invalidate the fact that Montez went through the first half of that trial without counsel. So I don't think we have any cases on point where a valid waiver has been found absent a colloquy that share really any meaningful similarities with Mr. Lucke. And I also do think just by way of the denial of counsel being inherent in that invalid waiver, that we do have plenty of reasoning there for structural error in this case. Unless the judges have any questions for me, I will ask the court to reverse Mr. Lucke's conviction.
Thank you. We appreciate the arguments from both sides today. They were excellent. They will be very helpful to us, and we will take the matter under advisement and let you have our written decision when we're able to get that taken care of. With that, we'll be in recess.